The Constitutional Court of Turkey is the highest legal body for constitutional review in Turkey. It examines the constitutionality, in respect of both form and substance, of laws, decrees having the force of law, and the rules of procedure of the Turkish Grand National Assembly. When necessary, it also functions as the Supreme Criminal Court to hear any cases raised about the President of the Republic, members of the Council of Ministers, or presidents and members of the High Courts. Overview. Part 4. Section 2 of the Turkish Constitution has established the Constitutional Court of Turkey, that statutes on the conformity of laws and decrees to the Constitution, and it can be seized by the President of the Republic, the government, the members of Parliament, or any judge before whom an exception of unconstitutionality has been raised by a defendant or a plaintiff. The Constitutional Court has the right to both a priori and a posteriori review, and it can invalidate whole laws or governmental decrees and ban their application for all future cases. Challenges to a law must be made within the first 2 months of its promulgation. Organization. In accordance with Article 146 of the Constitution of Turkey, the Constitutional Court is composed of 11 regular and 4 substitute members. The President of the Republic appoints 2 regular and 2 substitute members from the Court of Cassation, 2 regular and 1 substitute member from the Council of State, and 1 member each from the Military Court of Cassation, the High Military Administrative Court of Appeals and the Court of Accounts. 3 candidates being nominated for each vacant office by the plenary assemblies of each court from among their respective presidents and members, by an absolute majority of the total number of members. The President of the Republic also appoints 1 member from a list of 3 candidates nominated by the Higher Education Council from among members of the teaching staff of institutions of higher education, who are not members of the Council, and 3 members and 1 substitute member from among senior administrative officers and lawyers, to qualify for appointments as regular or substitute members of the Constitutional Court. Members of the teaching staff of institutions of higher education, senior administrative officers and lawyers are required to be over the age of 40 and to have completed their higher education, or to have served at least 15 years as a member of the teaching staff of institutions of higher education, or to have actually worked at least 15 years in public service, or to have practiced as a lawyer for at least 15 years. The Constitutional Court elects a president and deputy president from among its regular members for a term of 4 years by secret ballot and by an absolute majority of the total number of members. They may be re-elected at the end of their term of office. The members of the Constitutional Court are not allowed to assume other official and private functions, apart from their main functions. Composition. History. The Constitutional Court of Turkey was established on April 25, 1962, according to the provisions of the Constitution of 1961. Prior to that date, absolute superiority of the Parliament was adopted as a constitutional principle, with no judicial review. There existed no legal institution to review the constitutionality of laws passed by the Parliament, and of acts and actions of governments. The social democratic opposition, intellectuals, and the military junta that came into power by military coup on May 27, 1960 supported limitation and control of the parliamentary power in the face of abuses of parliamentary majority by the Democratic Party governments, under the premiership of Adnan Menderes. The Justice Party, a descendant of the Democratic Party, as well as Justice and Development Party, have rejected the idea of judicial review, pushing for parliamentary superiority. The first decision the court gave is dated September 5, 1962, which was published on the Official Gazette on October 3, 1962. It was about a direct petition by a certain Act to rerun for the annulment of an article of the law of criminal procedure, which was claimed to be violating the provisions of Article 30 of the Constitution. The court turned down the case, stating that individual application to the court was constitutionally impossible. The first president of the court was Sunu Hyasan, who served for 2 years. Following the second and the third presidents, the court failed to elect a president for 29 months, during which it was headed by an acting president. The articles of the Constitution regulating the structure of the court were slightly amended in 1971 and 1973, although the Constitution of 1961 was annulled by the military regime that came into the power with the military coup of September 12, 1980. The court went on operating. It currently operates according to the Constitution of 1982. Key decisions. Decision No. 1989 12th, dated 7 March 1989. The court, in response to then-President Kenan Evren's application for annulment of a law passed by Parliament, ruled that wearing headscarves in public universities violated the separation of religion and state. Decision No. 1994 halves, dated 16 June 1994. The court ruled to close the Democracy Party, a pro-Kurdish party, on the grounds that it violated the principle of territorial, national integrity and indivisibility. Decision No. 1998/1, dated 16 January 1998. The court ruled to close the Welfare Party, an Islamist party, on the grounds that it was violating the principle of secularism. Decision No. 2001 halves, dated 21 June 2001. The court ruled to close the Virtue Party, the successor to the Welfare Party. The decision, however, stated that the court did not consider the to be the continuation of the RP, but cited the Islamist policies followed by the party as the main reasons behind the closure. Decision No. 2001 330 seconds, dated 18 July 2001. The court, in response to applications made by regular courts, ruled that some parts of the amnesty law passed by the Parliament were unconstitutional, which resulted in a minor expansion in the scope of the proposed amnesty. Decision dated 30 July 2008. In the 2008 Justice and Development Party closure trial, the court ruled that the Justice and Development Party did not violate the separation of religion and state and did not close it, but noted that it had become a center for anti-secular activities, and cut the state's funding of the party's activities by 50%. Decision dated the 11th of December 2009. The court decided to ban the Democratic Society Party for its links to the Kurdistan Workers' Party, considered a terrorist group by the United States and the European Union. DTP violated Articles 68 and 69 of the Constitution and the Political Parties Law. The party became a focal point for terrorism against the indivisible integrity of the state, stated Hassam Kilik, president of the court.